Rule 112, Preliminary Investigation. Section 1. Preliminary investigation defined when required. Preliminary investigation is an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial, except as provided in Section 7 of this rule. A preliminary investigation is required to be conducted before the filing of a complaint or information for an offense, where the penalty prescribed by law is at least 4 years, 2 months, and 1 day without regard to the fine. Section 2. Officers authorized to conduct preliminary investigation. The following may conduct preliminary investigation: a provincial or city prosecutors under assistance. B. Judges of the municipal trial courts and municipal circuit trial courts. C. National and regional state prosecutor. And D. Other officers as may be authorized by law. Their authority to conduct preliminary investigation shall include all crimes cognizable by the proper court and their respective territorial jurisdiction. Section 3. Procedure. The preliminary investigation shall be conducted in the following manner. A. The complaint shall state the address of the respondent and shall be accompanied by the affidavits of the complainant and his witnesses, as well as other supporting documents to establish probable cause. They shall be in such number of copies as there are respondents, plus 2 copies for the official file. The affidavit shall be subscribed and sworn to before any prosecutor or government official authorized to administer of, or in their absence or unavailability, before a notary public, each of whom must certify that he personally examined the affiants and that he is satisfied that they voluntarily executed and understood their affidavits. B. Within 10 days after the filing of the complaint, the investigating officer shall either dismiss it if he finds no ground to continue with the investigation, or issue a subpoena to the respondent attaching to it a copy of the complaint and its supporting affidavits and documents. The respondent shall have the right to examine the evidence submitted by the complainant, which he may not have been furnished, and to copy them at his expense. If the evidence is voluminous, the complainant may be required to specify those which he intends to present against the respondents, and these shall be made available for examination or copying by the respondent at his expense. Objects as evidence need not be furnished a party but shall made available for examination, copying, or photographing at the expense of the requesting party. C. Within 10 days from receipt of the subpoena with the complaint and supporting affidavits and documents, the respondent shall submit his counter affidavit and that of his witnesses and other supporting document relied upon for his offense. The counter affidavits shall be subscribed and sworn to the certified as provided in paragraph D of this section, with copies thereof furnished by him to the complainant. The respondent shall not be allowed to file motion to dismiss in lieu of a counter affidavit. D. If the respondent cannot be subpoenaed or if subpoenaed does not submit counter affidavits within 10-day period, the investigating official office shall resolve the complaint based on the evidence presented by the complainant. E. The investigating officer may sit a hearing if there are facts and issues to be clarified from a party or a witness. The parties can be present at the hearing but without the right to examine or cross-examine. They may, however, submit to the investigating officer questions which may be asked to the party or witness concerned. The hearing shall be held within 10 days from submission of the counter affidavits and other documents or from the expiration of the period for their submission. It shall be terminated within 5 days. If within 10 days after the investigation, the investigating officer shall determine whether or not there is sufficient ground to hold the respondent for trial.